बेसिक बेसिक्स ऑफ द फंडामेंटल राइट्स। द फंडामेंटल राइट जो होता है पार्ट 3 में आता है ऑफ द इंडियन कॉन्स्टिट्यूशन, आर्टिकल 12 से लेके 35 तक। फंडामेंटल राइट्स इन इंडिया में द बोरोड फ्रॉम द यूएसए बिल ऑफ राइट्स से बोरोड किया गया है। राइट्स इन इंडिया में मच मोर एलिबरेट देन द यूएसए बिल्स ऑफ राइट। पार्ट 3 इंडियन कॉन्स्टिट्यूशन नोन एज द फंडामेंटल राइट गिवन इन पार्ट 3 ऑफ द इंडियन कॉन्स्टिट्यूशन जस्टिसेबल इन नेचर ये है। What is the justiciability? In the case of the violation of the fundamental rights, you can approach the court of for a resolution. Purpose of the rights क्या है? To create the equality, dignity of the individual, and unity of the nation. Three kinds of the justice given in preamble: social, economic, and political. Fundamental rights are the mean to the promote political justice in India. Social and economic justice promote the directive principle of state policy. The fundamental rights जो है guarantee the promote the by the constitution and the guarantee against the oppression of the state to promote people from the authoritarian government, essential for the around the all payment of the people to protect liberties and freedom to allow the people to develop themselves the fully poverty arbitrary action of the legislature and executives. द बेसिक्स ऑफ द फंडामेंटल राइट्स। ओरिजिनल कॉन्स्टिट्यूशन में 7 फंडामेंटल राइट्स हैं। आर्टिकल 14 से 18 में राइट टू इक्वालिटी, आर्टिकल 19 से 22 में राइट टू फ्रीडम, आर्टिकल 23 से 24 में राइट अगेंस्ट द एक्सप्लॉयटेशन, आर्टिकल 25 से 28 में राइट टू फ्रीडम ऑफ रिलीजन, आर्टिकल 29 से 30 कल्चरल एंड एजुकेशनल राइट, आर्टिकल 31 में राइट टू पॉवर्टी, आर्टिकल 32 में है राइट टू द कॉन्स्टिट्यूशनल रेमेडीज, राइट टू द प्रॉपर्टी, आर्टिकल 19A F and the article 31 deleted by the 44th Constitutional Amendment Act 1978. राइट टू प्रॉपर्टी लीगल एंड द constitutional राइट है आर्टिकल 300A ऑफ द इंडियन कॉन्स्टिट्यूशन। पार्ट 12 ऑफ द इंडियन कॉन्स्टिट्यूशन राइट टू प्रॉपर्टी एंड द 6 फंडामेंटल राइट्स रिमेनिंग रह गया है। Some fundamental rights some fundamental rights available only for the citizen. The article 15 prohibition discrimination on grounds of religion, race, caste, sex or place of birth. Article 16 equality of opportunity in matters of the public employment. Article 19 freedom under the rights to the right to freedom, and the article 30 right to the minorities to establish administrative educational institution। आर्टिकल 15, आर्टिकल 16, आर्टिकल 19, आर्टिकल 29, आर्टिकल 30 नॉट अवेलेबल फॉर द फॉरेनर्स, नॉट अवेलेबल टू पीपल होल्डिंग द OCI कार्ड्स and not available to the companies and the corporation. The fundamental rights available to the foreigner citizen and the companies and the corporation. Article 14 equality of before law equal protection of law. Article 17 abolition of the untouchabilities. आर्टिकल 18 एवोल्यूशन ऑफ टाइटल, आर्टिकल 20 प्रोटेक्शन रिस्पेक्ट ऑफ द कन्विक्शन ऑफ ऑफेंस, आर्टिकल 21 राइट टू लाइफ एंड द पर्सनल लिबर्टी, आर्टिकल 21A राइट टू द प्राइमरी एजुकेशन, आर्टिकल 22 प्रोटेक्शन अगेंस्ट द अरेस्ट एंड डिटेंशन, आर्टिकल 23 प्रोहिबिशन ऑफ द ट्रैफिक ह्यूमन बींग्स एंड द फोर्स्ड लेबर, आर्टिकल 24 prohibition of the employment of the children in the factories and the mines and hazardous industries, article 25 the freedom of the conscience and the free profession and practice and the propagation of the religion, article 26 the freedom to the manage religious affairs, article 27 freedom from the payment of the taxes promotion of religion, article 28 freedom from the attending religious structure and the worship of the certain educational institution, article 32 right to the constitutional remedies, Louis D. Redalt versus Union of India 1991, right, article 367 of the Indian Constitution, General Clauses Act 1897, the person include the corporation and the companies. Fundamental rights not available for enemy alien. Article 15. Prohibition of the discrimination on the grounds of religion, race, caste, sex, or place of birth. Article 16. Equality of opportunity in matter of the public employment. Article 29. 6. Freedom under the right to the freedom. Article 22. Protection against the arrest and detention. Article 29. Right to minorities, protect leagues and the spirit and culture. Article 30. Right to the minorities to establish administrative education. Fundamental rights no absolute. The reasonable restriction on can be imposed by the three states. Responsibility of the restriction to be the decided by the court. Purpose of the reasonable restriction may maintain a balance between individual rights and liberty and the social order, to prevent the enforcement and the rights of any person or for the right to other person. Two only fundamental rights absolute. Article 17 और आर्टिकल 24 रीजनेबल रिस्ट्रिक्शन है. इंडिया वेलफेयर स्टेट है, नॉट अ लेजर फेयर स्टेट. फंडामेंटल राइट्स ऑफ पीपल है, नॉट ऑफ नॉट unrestricted. No general pattern of the reasonable restriction can be laid down. The will vary from the case to the case basis. Content of restriction and the manner of the implementation both are the important. Reasonable connection में क्या था between the restriction and the objectives to be the achieved. The prevailing the social values should be satisfied using the restriction, and the restriction should be not be the greater than the mischief to be prevented. The restriction should be the reasonable, substantive and the procedural respects. A restriction में क्या है, should not be against the principle of the natural justice, and should not be based on the upon the satisfaction of the executives. Feature of the fundamental rights: all fundamental rights available against the state, and some fundamental rights available against the private individual or as well. Article 15, Article 17, Article 19, Article 21, 23, 24 available private and individual as well. The Article 29 and 21, the Kausal Kishore versus State of UP 2023, available against the state and non-state actors, available against the state and the private individuals. The fundamental rights may be the positive or negative. Negative fundamental rights impose restriction over the state action. Example: Article 15, prohibition of the discrimination on grounds of religion, race, caste, sex, or place of birth. Positive fundamental rights give privileges to the people. Article 25, freedom to profess, practice, and the propagate religion. Fundamental rights are justiciable in the case of their violation. A person can go directly to the Supreme Court. Fundamental rights not sacrosanct can be the amend. The Parliament can amend fundamental rights using the constitutional amendments. Article 368 can't be amend the basic structure of the Constitution. The suspension of the fundamental rights during emergency. Article 20 and 21 can't be the suspend during the emergency. Another fundamental rights can be suspended. Article 29 automatically suspended during emergency. Suspension of fundamental rights during the emergency if emergency in the ground of war and external aggression. If emergency can be grounds for the armed rebellion. Article 19 not be automatically suspended. A scope of the fundamental rights can be the curtailed. Article 31A, Article 31B, Article 31C can be used for the can be used for the cartel and the scope of the fundamental rights. Article 33. The Parliament can pass a law to the restrict the cartel of the application of the fundamental rights. Armed forces and the paramilitary forces, police forces, intelligence agency, and the legal services. Article 24. The application of the martial law, the military rule. The fundamental rights can be restricted. Article 35. The Parliament empowered to make law for enforcement fundamental rights. A state government can't be make a such law to ensure unfortunately and throughout the country. Article 12 deal with the dignification of the state. Definition of a state are part 3 of the constitution. State and mentioned in the define the constitution. Definition of a state: Government of India, Parliament of India, Legislative, Executive. Government of a state legislative, Legislative, Executive. And the local authority, Panchayat, Municipality, District Boards. And the other authority may mention in the Constitution. Not definition of the Constitution varies in a case based and upon the purpose of the ownership pattern. LIC, SALT, TPC, estate, and the Article 12 and BCCI and the NCR did not a state. The board interpretation of the state Article 12. It include only the authorities, private body working of the state also a state. Judiciary not mentioned in the Article 12. The judiciary function of the judicial function of the judiciary not a part of the state under the Article 12. Non-judicial administrative side of the judiciary state under the Article 12. The laws and the judicial review. Article 13. The provides for the judicial review of the law passed in the India. What judicial review not mentioned in the Constitution. The concept of the judicial review mentioned mm, and borrowed from the USA Constitution due to due process of law. Under judicial review, Supreme Court guardian of the protectors of the fundamental rights, judicial review only the review of the constitution of the law. Can't be review the wisdom and the lawmakers. The Article 13 make a fundamental rights justiciable, give teeth gives teeth to the fundamental rights. Article 13. The pre-constitutional law, if they are the innocent with the fundamental rights, wide for the label of inconsistency. After the recommendations of the Constitution, any law passed it is against the fundamental right, wide by the initiatives available in inconsistency. Word law mentioned in the Constitution definition in the Article 13. What all in the included in the law made by the parliament or a state legislature, ordinance the ordinance promulgated by the president and governor, delegated legislature may order by law, rules, regulation, and notification, custom and uses having the force by the law. Article 13 impose a restriction on the legislative versus state as well as the executive action भी होता है. Constitutional amendment में not consider law under the Article 13. After the 24th Constitutional Amendment Act 1971, constitutional amendment can't be the challenge in the court of law. If the constitutional amendment go against the basic structure of the constitution, can be the declared null and void. Keswananda Bharti versus State of Kerala 1973. The right to the equality, Article 12 to 18. And the Article 12. The available against the state, all available to the citizen, foreigner, companies, corporation, and other legal person, and not absolute in nature. Reasonable restriction allowed. Equality before law. negative in nature borrowed from the UK Constitution, equal protection of the law, positive in nature borrowed from the USA Constitution, and the law rule of law professional dice of the UK से किया गया absence of the arbitrary power, no person can be the punished except from the breach of the law, equality before law, absence of any special privileges favor in the any person. Everyone is equal in the front of law, no person is above the law, and law is administered by the court. यूके में क्या होता है, primacy of the individual rights, the constitution is the result of the right of the people, constitution is not the source of the rights. इंडिया में कहा था कॉन्स्टिट्यूशन इज द सोर्स ऑफ द राइट्स एंड ऑफ द पीपल एंड द बेसिक स्टेट्स है इक्वालिटी बिफोर लॉ एंड आर्टिकल 14 पार्ट ऑफ द बेसिक स्ट्रक्चर इक्वल प्रोटेक्शन ऑफ द लॉ. The equality and treatment under the equal circumstances in the term of the original liabilities, a similar application of the laws by the people and the similar situation like to be the treated alike. The equal protection of the law allows the different treatment of the different circumstances. Reservation come from the equal protection of the law, article 14. Reasonable uh, classification of the purpose relation allowed. Classification should not be the arbitrary. No class legislation allowed. What is the class legislation? Legislation to this legislation is disproportionately favor in the harming the specific class of the people. Exception in the equality, article 361, immunities and the immunities and the president and the governor. Not allowable. Any court and anything done in the office reads, two of the amendments can't be issued against the president and governor. No criminal proceeding against the president and governor when they are in the office. No court of the issues the arrest order in imprisonment order of the president can go on in the office. Civil proceedings can be the initiated after the prior office of the 2 months. Exception to the Article 14. Article 361A, inserted by the 44th Constitutional Amendment Act 1978, and no person shall be held in the liable in the any court for the publishing their report in newspaper the regarding any proceedings of the either house of the parliament or state legislature. Article 105 and article 194, no member of the parliament or state legislature to be held liable to anything in said or any vote on the floor of the house the any committee. Article 31C, inserted by the 25th Constitutional Amendment Act 1971, law made by implement the Article 29B and Article 29C can't be challenged in the court of law. For the violating the Article 14, the Supreme Court, where the Article 31C come in, Article 40 goes out. Exception to the Article 40, the foreigner rulers, ambassador and diplomats, diplomatic community. Article 15. Article 15, prohibition of the discrimination on the grounds only in the religion, race, caste, sex, or place of birth. Available only to the citizen, not to be the foreigner, companies, and the corporation, etc. Negative fundamental rights available against the state as well as private individual. Not absolute. Reasonable restriction allowed. What discrimination mentioned in the Constitution but not in definition and of the Constitution. Discrimination to the put someone in the disadvantage. Discrimination unfavorably The word only. The discrimination of religion, race, caste, sex, place of birth not allowed. Discrimination on the grounds of the allowed in discrimination on grounds of age, economic status, language, and marks, etc. Article 15(2). No restriction, liabilities, and availabilities of the imposed upon the any citizen on the grounds only the religion, race, caste, sex, place of birth, with the regard of the access to the shop, public restaurant, hotel place of the public entertainment, use of the well tank and the bathing ghats, roads, and the place of the public resort, the maintained by the partially or wholly out of the estate, found the dedicated to the use the general public, available against the estate as well as the private individuals. Reasonable restriction, estate, a special provision for the women and children, a reservation of the seat for the women and panchayat municipalities, state legislature, Lok Sabha, a special provision for the advantage of the especially and educationally backward classes, scheduled classes, and scheduled tribes. Example is a reservation of the seats added by the first constitutional amendment act 1951, a special provision for the advance of the socially and educationally backward classes, scheduled class, and the scheduled tribes to the respect their admission and the educational institution. Example, reservation in educational institution, reasonable restriction, including the private educational institution, whether they are led and the unpunished minorities educational institution not allowed, added by the 93rd Constitutional Amendment Act 2005. The 103rd Constitutional Amendment Act 2009, a state can make the provision for the advanced economic weaker section. A state can make the provision for the upon the 10% reservation education institution EWS, including private educational institution, whether they aided or unaided. Minority education institution not include in this the no criteria in the article 15. The in determine the backward classes to define definition of the socially or educationally backward classes given up to the government to the decide. Caste can't be solved. The criteria for the decided backward classes, caste and classes or the different. SC/ST to be determined by the central government, OBC to be the determined by the both central as well as state government, up to the 10% reservation for EWS over the above reservation for SC/ST EWS only for the those who are not covered by the existing quotas EWS and to be determined by the state government. On the parameters of the family income and the parameters of the economic disadvantage, 27% reservation educational institution for the OBCs, socially and educationally backward classes, a creamy layer to the entitled to reservation, not entitled to reservation, a reservation special enabling to the provisions and to the uplift there the backward section and not to the fundamental rights. If the state is not giving to reservation, you can't be approached to the Supreme Court. Article 16. Article 16, equality of opportunity in matter of the public employment, positive fundamental rights and not absolute reasonable restriction available. Available against the state only, available to the citizen only, not available to the foreigner, corporation and the companies extract. Article 61 A. Uh, Article 60A, the equality of opportunity for all citizens in matter of the public employment. Article 62nd, and not no discrimination on matter of the public employment, only the grounds of religion, race, caste, sex, a decent place of the birth and residence. Reasonable restriction, parliament by the law can be the prescribed the residence as a condition in the certain types of the employment. Example: Public Employment Act 1957. This act is expired later. 32 of the Constitutional Amendment Act 1973. Article 37 1, Article 371D, inserted by the Indian Constitution, for the Andhra Pradesh and Telangana, pursuant on the aid and advice of Union Council of Ministers, create residence and the as a condition of the certain jobs Andhra Pradesh and Telangana. Article 371D, extended to the Telangana. Andhra Pradesh Reorganization Act 2014. Article 16 for reasonable restriction. A state can provide reservation to the any backward classes of the citizen not adequately reserved in the any services. Using this clause, a state has provided for the reservation in the public job SC, ST and OBC. Article 16 4A, added by the 77th Constitutional Amendment Act 1995, to give the reservation for promote SC, ST which were not adequately represented in the state service. It will consequently seniority. OBC, no reservation in the promotion. Article 16 4B, added by the 81st Constitutional Amendment Act 2000. It if reserve the vacancy uplift the particular year, a state can fulfill them the succeeding the year as a separate group of the vacancy, not to be the mix with the vacancy of the specific year. In the such case, no claim can be the made regarding a breach of the 50% reservation limit. Article 16 fifth, Parliament by the law prescribed that any office holders of a religious institution should be belong to the specific religion, can be the prescribed specific religious qualification for the post related to a specific religion. Article 16 6, added by the 103rd Constitutional Amendment Act 2019, a state empowered to make up to the 10% reservation in the public job in the favor of the economically weaker section over the above the existing reservation for backward classes. No reservation to promotion of the EWS to be defined by the state, not defined in the constitution, on the grounds of the family income and a parameter of the economic deprivation. The certain specific jobs, the requiring core a scientific skill exempted from the reservation. Article 340. The President may order the appoint the commission to the define the procedure for allowed them on the aid and advice of the Union Council of Ministers to investigate condition of the socially and educationally backward classes, give the recommendation to the union and state regarding the state can be taken to remove difficulties and improve the condition. Grants should made by the union or state. Commission will submit their report on the president. The constitutional duty of the president table on the report before the each house of the parliament, along with the explanatory recommendation of the action taken using the powers under the Article 340 the Indian Constitution. The first backward classes commission, Kaka Kalkar 1953, and the second backward class commission, BP Mandal 1979. The Mandal Commission आया recommended to 27% reservation for the public job and for the OBC community. Indra Swaney case, Indra Swaney versus Union of India 1992, uphold the constitutional validity for the 27% reservation for the OBC. Advanced layer of the OBC, creamy layer, should not give them reservation, and no reservation in promotion of the OBC. Total reservation should not be the more than the 50%. Carry forward by the uplift the vacancy can be done. The department body look into the cases of the OBC should not be established. And the backward classes of the citizen not defined in the constitution. Backward class of the citizen parameters of the determines of backward classes: caste, sex, caste, opposition, poverty, social backwardness, and the place or the residence and level of the education. In Hinduism, the caste order and criteria can be used in the definition identify OBC in order to the religion and their other in the one of the caste other the parameters of the mentioned in above in identification of the backward classes subject to the judicial review and the means test uh, to be used in the to identify creamy layer the based on the opinion income opportunity and the economic parameters as sub classification of the OBC allowed into the creamy layer and non creamy layer. A sub-classification of the SC and ST not allowed. The National Commission for Backward Classes created by the statutory body 1993 Government Action 100 to Constitutional Amendment Act 2018 made by the constitutional body Article 338B and dividing the Devinder Singh case में स्टेट ऑफ पंजाब और से देविंदर सिंह 2024 सब categorization of the scheduled caste and scheduled tribes allowed and the rational principle of the sub categorization should be used. The sub classification means the achieve equality. The schedule caste and not the homogeneous and inequalities within the schedule caste and the state and the center can be done there the respective subcategorization. Article 335 claims of the scheduled caste and the scheduled tribes to be reserve and the post shall be taken into the consideration by the government and the efficiency of the administration should be maintained. And for the dealing with the claims of the SC and SC state can be the lower down and the qualification makers and the lowering the standard of the evaluation in the examination of the promotion added by the 82nd Constitutional Amendment Act 2000, the directives to the state given by the Constitution. Article 16. The equality of opportunity in matter of the public employment include restriction, promotion, retirement, and post retirement benefit. It is the not just limited to the entire level equality. Article 17. Article 17 Evolution of the untouchability and the practice in any form. And negative fundamental rights, absolute rights, no reasonable restriction on possible available against the state and private individual, available to the citizen as well as foreigner. Any disabilities arising out of the untouchability, the punishable offense, as per the laws made by the parliament. The word untouchability mentioned in the constitution no defined and the no restrict definition. Protection of the civil rights article 1955 passed by the parliament. Dealing with the offense and related to the untouchability. Untouchability is not a definition in this law. Protection of the Law Rights Act 1955. Refugee admission in any public institution on the grounds of the caste, preventing any person from the offering the prayer at the place of the public or public worship, the preventing access to the any shop, restaurant, hotel, etc., insulting of the member of OBSC community, preaching any justifying the untouchability for the fine, imprisonment, disqualification from the election. The untouchabilities includes not just by the physical sense of the untouchability, but both in the case of the disabilities also arising out of the birth and a specific caste and the look into down upon the deserved classes and the objective to be abolish caste system. Article 18. Article 18, abolition of the title. Negative fundamental rights available to the citizen and the foreigner, not absolute. Reasonable restriction allowed. Available only the against the state. A state can't be give the title to any individual. Reasonable restriction. And the military and educational title are allowed. Citizen can't be receive the title from the any other foreign country. Any foreigner in the service of the state or holding the any office of the profit can be accept title from the foreigner state after the consent of the President of India. Any citizen of the foreigner in the service of the state and holding the any office of the profit can't accept any gift and the emolument and services from the foreigner state without the consent of the President of India. The purpose of the Article 18 to the create equality amongst the all. The Balaji Bagh the Bhagavan versus Union of India 1995 national award like the Bharat Ratna and the Padam Vibhushan etc. The note against the Article 18 that these awards are not titles, a way of the recognition of recognizing merit. These awards should not be used in the prefix and suffix to the name. Right to freedom, Article 19 to 22. Article 19, the six freedoms given under the Article 19. Right to the freedom of speech and expression. Right to the assembly peacefully without assemble peacefully and without arms. Right to the form association, union and cooperative society. A cooperative society is added 97th Constitutional Amendment Act 2011. The right to move freely throughout the territory of India. The right to the reside and settle in any part of the territory of India. Right to carry out of the occupation, trade and businesses. Original Constitution 7 freedoms. Article 19 AF. Right to acquire, hold any disposed property. Deleted by the 44th Constitutional Amendment Act 1978. Currently six freedoms in the Article 19. Article 19(6) freedoms, positive fundamental rights available only the citizen, not foreigner, available against the state as well as a private individual. Kausal Kishore versus State of UP 2023. Article 19(6) freedom, not absolute. Not absolute reasonable restriction, only a grounds of the mention in the Article 19 and not only on any other grounds. The freedom of the speech and expression, right to the express the view and the opinion of freely, oral, written, printing and picture, video, etc. On the writings includes within the freedom of the speech and expression, right to the press and media, right against the universality repeating, right to the social media, right to the circulation, freedom of the advertisement, right to against the phone trapping, right to the telecast, and no government monopoly on the television. Right against the hartal, right to information, right to the stay salient, right against the pre-censorship of newspaper and the magazine, right to the fly national flag, right to the vote, right to the vote to the know about the credibles and the candidates, right to the choose their medium and the infrastructure in school, right to the express gender inequality, reasonable restriction over the freedom of speech and expression में sovereignty of integrity of India, security of a state, the friendly relation with foreign state, public order and the decay of the morality, contempt of the court, deformation and the incitement of any offense. Incitement of any offense. A reasonable restriction should be have the breaking the law. The executive action without legal backing, the ultra virus. The reasonable restriction, the no mention in the balance between individual liberty and the social order. Common goods given to the uh, preference over the individual liberty. American Constitution may reasonable restriction not mentioned in the Constitution up to the courts and decided by the reasonable restriction. And no Indian Constitution में क्या है, grounds of reasonable restriction mentioned in the within the Constitution. Indian Constitution only those grounds reasonable restriction can be imposed, not any other grounds. The Indian welfare state, the not laissez-faire and the unrestricted rights. Hence a reasonable restriction भी है. Freedom of the assembly peacefully without arms, right to hold the public meetings, right to the hold peacefully a demonstration, right to the take up the peacefully profession, and not violate movement and the protect the are allowed. Freedom assemble and peacefully without arms, any assembly causing the public innovation are not allowed. This does not include in the right to the strike, allowed only in the public land. Reasonable restriction sovereignty integrity of India. Public order में सेक्शन 144 of कोड ऑफ द क्रिमिनल प्रोसीजर 1993 restricting assembly on the more than 4 people on the grounds of the obstruction anywhere and danger for the human life and the health restrictions and the um, trans equality. The example section 141 of the Indian Penal Code. The assembly of the more than the 4 people is unlawful if their purpose is to the prevent in execution of the any law, prevent any official form of the exercising their the lawful powers, the occupy any property of any person, mischief and the force someone to the do all legal tasks. The freedom to for association, union and cooperative societies. The purpose to should be the lawful, the right to from the political parties and the companies and the partnership fines, right to the form of the societies, public and organization, right to the form trade union, right no right to the strike or the lockout. The include right not to the join any association or union, trade union, no right to have effective bargaining if the name is there in the illegal organization by but you are not involved in the activities, it is not a crime. Reasonable restriction, sovereignty and the integrity of India, public order, morality, right to the move freely throughout the Treaty of India. India is not one unit, a citizen free to move anywhere, only deal with the internal movement within the country, not with the travel abroad. Reasonable restriction, interest of the general public, interest of the scheduled tribes, entire into the tribal areas restricted to protect their the customs, occupancy and language. Entry restriction in the inner lines permits areas. Restriction on the movement of the other prostitutes in the interest of the general public. Freedom of the residents, right to the reside and settles in the any part of the Treaty of India, reside the temporary estate at a place, the settle the permanent longer terms settlement at the place to promote the sense of the national unity. Reasonable restriction in the interest of the general public, in the interest of the scheduled tribes residing the settling the tribal areas. Prohibited to the promote their the culture, customs, rights and property rights and language etc. The prostitutes and the habitual offenders can be the restricted from the residings and the settling there the area, certain areas, right to the practice any occupation, trade or businesses. reasonable restriction in the interest of the general public, a requirement of the necessary professional or technical qualification. A state can exclude any citizen from the specific trade and business or services completely or the partially. A state is not required to justify its monopoly, can't carry out a moral or a dangerous occupation. A state can be prohibit them. Uh, Anuradha Basing versus Union of India 2020, the freedom to carry out any occupation, trade and businesses over the interest in also fundamental rights. Article 19 AG, suspensions of the interest service indefinitely. The impact of the right and occupation, trade or businesses. Article 20, protection in the respect of the conviction for the offense, no ex or ex post facto legislation, no double jeopardy, and no self incrimination. Feature of the Article 20, the positive fundamental rights available to the citizen, foreigner, companies and the corporation, available only against the state. uh, Not absolute reasonable restriction allowed, protection from the arbitrary executive punishment, not ex officio facto legislation. In the in criminal cases, no punishment can be given to the retrospectively. The law applicable on the data of the committee offense and punishment according to their law. And the person can't be the made by the suffer more due to the retrospective law. In the penalty penalty greater than the prescribed by the law on the data of offense. The civil and the taxation of the law can be passed by the retrospectively, not applicable in the case of the preventive detention. A trial procedure can be the change in the retrospectively. Limitation over the law making power registration in the India. No double jeopardy. No person shall be punished from the same offence more than once. Applicable only the case of the court proceedings and the cartel not available in the case of the executive department or the authority. If any same crime repeated against a person can be punished against the no self incrimination in the no person shall be compelled to the witness against him, applicable only in the criminal proceeding, not applicable in the civil proceeding. No person can be forced to give the oral and the documentary evidence against him. The compulsory narco test not allowed. The exception, searching the premises of the accused is allowed. And the thumb's impression, signature, voice sample, handwriting samples allowed. Article 21, the protection of the life and the personal liberty. No person shall be deprived of the life and the personal liberty except according to the procedure established by the law. Are features of the Article 21, the positive fundamental rights available to the both citizen and the foreigner, and the not absolute reasonable restriction allowed, the available against the state and the private individual. And the Kausal Kishore versus State of UP 2021, AK Gopalan versus State of Madras 1950. The Supreme Court, a narrow interpretation of the Article 21, the power of the Parliament to take away life and liberty absolute, and the Parliament can pass the law to take away life and liberty. Any such law can't be the challenge in the court law. Immunity of the such law from the Article 13. The Menka Gandhi versus Union of India 1978, overruled by the judgment and passed by the A.K. Gopalan. A border interpretation of the Article 21 of the Constitution, introduced in the concept of due process of the law, American concept. The power of the Parliament to the pass the law to take the life and liberty. The not absolute can be the subject to the due process of law. Article 13 is applicable to the law passed under the Article 21. The procedure to the take away the life and liberty must be just, fair, and reasonable, should not be the arbitrary. The procedure to take away the life and liberty should the conform the principle and the of national justice. The Menka Gandhi versus Union of India right to the life and does not miss the existence. Animal existence include right to the life and life with the dignity. Personal liberty may widest amplitude implied the fundamental rights. Some of the derived implied the fundamental rights covered under the Article 21 are the right to the decent environment, right to the pollution free air and water, right the protection against the industrial hazardous, right to the livelihood, right to the privacy, right to the shelter, right to the health, right to education, right to the free legal aid, right against the solitary the confinement, right to the speedy and the fair trial, right to the against the handcuffing, right against handcuffing, right to the travel abroad, right against the right bonded labor, right against the custodial death, right to sleep, right to the freedom from the noise pollution, right to the sustainable development, right to the opportunity, right to the decent burial and the crimination, right to the love and the right to the marriage, right to the passive euthanasia, right the lie lie doctor narco test brain mapping. The can't be the done in the without the consent of the person. If done without the permission, violation of the right to the privacy. The institution into the national privacy, the khap panchayat, the illegal no locus standi, standi against the right to the marriage, the decentralization of the homosexuality, section 377 of Indian Penal Code against the right to the dignified the life and liberty, a right to the right of the elderly to have the genetic care, right to the pension, right to the shelter, right to the females to the make a reproductive choice, right to the bodily integrity, freedom to choose the contraceptive and birth control methods. Landmark judgment related to the Article 21, Satwant Singh versus Senavi versus Dr. Ram Ratna versus Assistant Passport Officers 1967. Right to the travel abroad. M.H. the Hoskert versus State of Maharashtra 1978. Right to the free legal aid. The Husainara Khatun versus Home Secretary Bihar 1971. Right to the speedy trial. The fencing Coriolis Mulini versus Administrative Delhi 1981. Right to the life with dignity. Right to the prisoner to have the necessity of life. The Sila versus State of Maharashtra 1983. Right against the custodial harassment. Rural litigation of the fundament entitlement of the Kendra versus State of the UP 1985. Right to the decent environment. Olga Tellis versus the Bombay Municipal Corporation 1985. Right to the livelihood. The Paramanand Katra versus Union of India 1989. Right to the doctor's assistance. The Shanti Satra versus Builder versus N.K. Tollman 1990. The right to the shelter. The case the Puttaswamy versus Union of India 2017. The right to the privacy. The common causes of a Union of India versus Union of India 2018. The right to the passive euthanasia. Right to the die within dignity. The Prega Prasoon versus Union of India 2024. The Amar Amar Jain versus Union of India 2015. Right to the digital access. The covered under the right to the life, the exclusive digital ecosystem accessible to the all, a reduction in the digital divides necessary for the defined life, and the all digital service available to the marginal and the vulnerable section. The unequal section of the digital infrastructure, and should be the should bridge the constitutional and the obligation of the government, and the most impact of the section this balance between the section of the ruler population, the supremacy of the uh, Chakravarti versus Union of India 2023. No fundamental rights to the marry. The no fundamental right to the marry available to the homosexual couples. Only the heterosexual marriages allowed. The fundamental rights choose the partners and the have to the intimate relationship available. Article 21A. Education. Originally Constitution stateless. The 42nd Constitutional Amendment Act 1977 76 transferred to the concurrent list. The Moni Jain versus State of the Karnataka 1993. Fundamental Rights of Education at all levels of the education. The Uni Krishna versus State of the Andhra Pradesh 1993. The rejected to the Moni Jain versus Moni Jain judgment. Right to the education is a fundamental right under the Article 21 and the right to the Constitution for the primary education 6 to 14 years of the age. Right to the education inserted by the 86 Constitutional Amendment Act 2002. The Article 21A duty of the state free and the compulsory education children from the age group of the 6 to 14 years in the manner should be determined by the state feature of the Article 21A positive fundamental rights. The not absolute reasonable restriction allowed available only the against the state available to the citizen and the foreigners. The fundamental rights only for the primary education case 1 class 1 class 8, the pre-primary higher and the professional education not included in the list of the fundamental rights to the implement Article 21A right to the children to the free compulsory education Act 2009 to the children in the age group 6 to 14 years of the age, the private educational institution to keep aside 25% of the seat of the economically weaker section. Right to education. Right to the quality education without discrimination, qualified teacher and the basic infrastructure. Article 22. The protect against the arrest and the detention. Arrest a person in this the custody of the laws enforcement authorities during the preparation attempt and the commissioning of the offense. Changes in the imposed for the specific crimes. The determination of the two types, the preventive detention, the punitive detention. The preventive detention, a person determined by the before the crime no grounds of the suspension, reasonable suspension, or and that a person involved in any law made by the involved in the crime to prevent the crime. No trial for the convention involved. The intention of the punish a person, quick measures for the prevent offense, no charge imposed. A punitive detention, a person is the custody after the court has given the sentence. A person is the custody after the punishment, after the trial and the convention. Charges have been the proved. The feature of the Article 22 positive fundamental rights, no absolute reasonable restriction are they are the available to the citizen and the foreigner except the enemy alien, available only against the state. Article 22 two major parts, the prevention related to ordinary law, provision related to the preventive detention law, the provision related to the ordinary law when the person is arrested and the detained detained in order to the in the any ordinarily or right to be the informed about the grounds of the arrest, the right to the consult and the defend by the legal practitioners. Right to the procedures and the before the nearest magistrate within the 24 hours. Jury of the time excluded. Reasonable restriction protection in the case of arrest not available to the criminalize protection not available to prevent the detained under the preventive detention law. Deprivation of the any alien arrested order issued by the court. Arrest due to the non-payment of the income tax. Civil arrest. The protection under the Article 22. The available in the criminal case, the quasi-judicial case, and the instance when the public order any law disturbed. The preventive detention law. The Parliament only the Union list the defense of Union foreign affairs and the security of India. And the parliament and state legislature both concurrently security of the state and the public order supply of the essential commodities. Second part of the article 22 protection in the case of the detention under the preventive detention law. The protection in the case of the detention under the preventive detention law available to the both citizen and the foreigner including enemy alien. The maximum period of the preventive detention 3 months to extend the preventive detention any advisory board to the created imposing the high court and the judges of people in the high court judges this board is extended to duration of the preventive detention. Maximum duration the preventive detention after the approval of the advisory board. National Security Act 1981 year applicable in the entire India. The Public Safety Act 1978 2 years applicable in the Jammu and Kashmir and Ladakh. The board can extend the preventive detention only up to the limit specific in the law. The grounds of the detention should be the communicated to the detainee and soon as possible. The given detainee to the earlier an opportunity to make representation against the order. Fact that against the public interest should not be the disclosed. And the powers of the parliament to make law prescribing the maximum duration for the preventive detention. Case in the such person can be determined more than 3 months without any approval of the advisory board. The lay down the procedure to be allowed in the advisory board preventive detention law. The available only in India, the USA. No concept of the preventive detention. UK preventive detention used only for the world wars. The right against the exploitation. Article 23 to Article 24. Right. Article 23. Provision of the traffic of the human beings and the forced labor. Negative fundamental rights available to the citizen and the foreigners. Available against the state and the private individual, not absolute reasonable restriction allowed. Prohibition human trafficking bearers other the forms of the forced labor including the human trafficking or forced labor in the offense as per the law. No person can be forced to work against his will. No no devdasi system, no bonded labor, no promotion of prostitution, no work of the without payment and the minimum wages as per person as their right to the refuse their to the work. Article 23 supplement of the provision of the Article 21 the personally liberty laws passed using the prevention of provision of the Article 23. Immoral Trafficking Preventive Act 1956, the Bonded Labor System Abolition Act 1976, Minimum Wages Act 1948, Contact Labor Act 1970. The Equal Remuneration Act 1976, and the reasonable restriction state can impose the compulsory services for the public purposes and no discrimination on the grounds only for the religion, race, caste, sex, or places of social services, military services. Military services. Article 23, the supplementary and the provision of the Article 15, the provision of the article discrimination. Article 24, provision of the employment or children in the factories, etc. Negative fundamental rights available to the citizen and foreigner, available against the state as well as a private individual. Absolute fundamental rights. The no children below the age of the 40 years employed to the work in the factory, mines, and the hazardous industry. Children working in the entertainment industry is allowed. The not prohibited any by the article 2024 laws prohibiting the child labor, child and the adolescent labor prohibition and the regulation act 1986, employment of the children act 1938, the factories act 1948, the mines act 1952, the merchant shipping act 1958, the plantation labor act 1951, the motor transport worker act 1951, Appropriate, the Apprenticeship Act 1961, the BD and the Cigar Work Act 1966, Children and Adolescent Labor Provision the Regulating Act 1986. Children below the age of 14 years can't be employed anywhere, including the dhabas, hotel, teas, shop, etc. Children below the 14 years can only work in the family enterprises in the case of the urgent financial situation, and the only after the school hour only after the school hours. 14 to 18 years of the age children can be employed, both the not in the hazardous industries. A step taken from the government for children welfare, the child labor Rehabilitation Welfare Fund, the Commission for the Protection of the Children Right Statutory Body, establishment of the Children's Courts. The right to the freedom of the religion, Article 25 to 28. Article 25. The freedom of conscience and free profession, practice, and the propagation of the religion. Positive fundamental rights available to the citizen and the foreigner. Available only the against the state, not absolute reasonable restriction allowed. What the religion? As the mentioned in the constitution but not definition anywhere. Freedom of the conscience, freedom of the entertain your beliefs and the faith system, freedom of from the relationship with the god where whatever you are want the you have to the certain opinion about the religion, the right to the profess the declare your the belief and the faithful openly, and the right to the practice the perform the rituals and the ceremonies of the specific religion, the right to the propagate transmitting the religious belief and their other people religious conversion, the conversions by free will be allowed, the forcible religious convention not allowed. Article 25 the covers the religious beliefs and the religious practice both the reasonable restriction public order health or morality other provision of the part second third of the constitution. A state can regulate economic financial and the political activities of the secular natural related to a religion. Example, management of the properties, land, maintains the public order and the discipline, jali kattu, etc., can be the regulated by the law. Example, offering the food and the milk in the Hinduism. Essential religious practices can't be the regulated by the law. A state can be passed for the social perform the social welfare will be counted as a violation of the fundamental rights. Example, laws prescribing monogamy, law abolishing the tribal triple talaq, Hinduism, religious and the religions and institution of the public character can be thrown the open the section of the Hindu remove the caste discrimination and untouchability. Any person belonging to the caste and sect should be the not the stopped from the entertaining Hindus and the religious institution of the public character. Jain, Sikh and the Buddhist institution can be the thrown upon the all section of the Jain, Sikh and the Buddhist. Wearing the kirpal by Sikhs, an essential religious practice of the Sikh under the Article 25. Article 26. Article 26 freedom of the marriage, religious affair, positive fundamental rights available only against the state, available to the citizen as well as a foreigner, not absolute reasonable restriction allowed. Right to the religious denomination to establish and maintain the institution for the religious and the charitable purpose, to manage the own affair, to in the matter of the religion, to on the acquire the removable immovable property and the administrative it's a law by law. Article 25 the individual religious freedom. Article 26 collective religious freedom of the purpose and the denomination. And the what is the religious denomination? Collective individual having the common faith system, having the common organization, having the distinct name. Example: Ram Krishna Mission. That is never restriction of the Article 26 public order, morality or health. Article 27 freedom as the payment of the tax for the promotion of the any particular religion, positive fundamental rights available only the against the state, available to the citizen as well as foreigner, not absolute reasonable restriction allowed. No person can be the compelled to the pay the tax money from the which the can be used for promotion of or maintaining the specific religion. Denomination. A state can be an a state we can patronize the favor of the religion and the over the other. Taxes can be used for promotion of the all religion but not be a specific religion. A special fee can be levied, can be provided a special services facility for the pilgrimage, for maintenance of the shrine or trust free and the tax of the different. Article 28 freedom as the attendance of the religious instruction in the educational institution, positive fundamental rights available to the citizen and the foreigner, available only the against the state, not absolute reasonable restriction allowed. Any educational institution maintained by the fully from the fund of the state, not a religious institution, can be allowed maintained by the run by the religious trust. Religious instruction can be given. A student can't be refused to attend the instruction. The private educational institution or the institution receiving aid from the state the may given to the religious instruction. A student may not be the complete to the allow it. The cultural and the educational right of the Article 29 to 30. Article 29 protection of the interests of the minorities, positive fundamental rights available only to the citizen, available only against the state, not absolute reasonable restriction to imposed. And the section of the citizen giving them the treaty of India having the rights. No reserve, no preserve their language, spirit and culture. Right to the protect language, spirit and culture. Collective fundamental rights given to the group of the citizen. Absolute fundamental rights. Reservation for the people act 1951. Seeking the vote of the name of the religion and the state not allowed. The seeking the votes of the name of the of language not allowed. The candidate can be commit their work for the conservation of the language, it is allowed. Not no citizen shall be denied the admission in the educational institution maintained by the state or the preserving the and receiving aid from the state on the grounds of religion, as caste, sex or language. right against the denial of the admission of the educational institution given to the individual and citizen, irrespective of their the groups and the past. Supreme Court protection under the Article 29, the religious and the linguistic minorities and the other citizen also denying the admission and the grounds of the religion, race, caste, sex, language allowed, not a violation of the Article 29 Act for residence marked age. Article 30 right to the minorities and establish the administered educational institution, positive fundamental rights available only to the citizen, available only against the state, not absolute research. Reasonable restriction allowed all minorities, religious and the linguistic minorities have the right to the establish their the administered educational institution, religious and linguistic, two types of the minorities recognized by the constitution, recognized by the Article 30, not defined in the constitution. And the religion minorities considered at the any all the Indians level, having the less than 50% of the population determined by the central government. Linguistic minorities considered in the state wise manner, having the less than the 50% population. The determined by the state government, and the right to the minorities and establish the administered educational institution. The tools, the governing body and institution, the point the teaching and non-teaching staff and take action against the defaulting employees are decided by fee structure and the decision criteria. Right to the maladministration institution, right establish an administration educational institution. No absolute standard can be laid down the maintained educational and education alliance, a standard of the ensure the efficiency and administration. State regulating regarding the employment syllabus, examinations and exam scheme are not available of the Article 30. Article 31A, inserted by the 44th Constitutional Amendment Act 1978, if the state is a maximum any law and the compulsory acquisition of the property and the minority educational institution, adequate composition of to be given. And no ensure the right to the minorities educational institutions are not violated. A right to the property and to the minorities only in the case of the educational institution, in the granting aid, and the educational institution shall not be the discriminate against the religious and the linguistic minorities. Educational institution receiving aid from the state will not be challenged in the character of the minority educational institution. Article 29 and the given the right to the all citizen minorities and the majority and the minorities. Article 30 right to the confined only the minorities, right to given to minorities bring the at the power to majority. The minorities not treated majorities, and no discrimination in the favor of the minorities. Right of the minorities to impact education of their children in their the own language, and the institution established under the Article 30 should be the established under the administered by the minorities only. Institution established by the majority community for the benefit of the minorities can't be given. The protection under the Article 30 should be help the minorities to cover the language and religion, should be the impact their good education children belonging to the minorities. Right to the property, Article 31. The Article 31 compulsory acquisition of the property repealed by the 41st Convention and Act 1978. Original Constitution Art. Article Article 19 AF, the freedom of acquire hotel and the disposal property. Article 31, the right against the depreciation property and both the citizen and the foreigner. Article 31, a state had the power to acquire the property of the any person only using the authority of the law, should not be public purpose denied, the compensation of owners should be given. The 44th Constitutional Amendment Act 1978 inserted Article 300A in the Part 14, the right to property, constitutional and the legal right, also considered the basic human rights, not a fundamental rights anywhere. Not a part of the basic structure of the Constitution, a person shall be derived by the history the property except according to the law available in the both citizen and the foreigners concurrent list the property acquisition center and estate both make the laws and right to the property can be made taken away by the law and the passed by the legislative and the simple majority. Property includes land, intellectual property, real estate, and copyrights. The executive can't acquire the property without the backing the legislature. The Article 300A, the protecting against the arbitrary executive action in the case of the violation, can't be go on the Supreme Court directly, can't be approach the High Court directly. Article 226, the guarantee of the compensation mentioned in the Constitution to be the decided by the law. Saving the certain laws. Article 31A, Article 31B, Article 31C, Article 31A, Article 31, saving of the laws providing for the acquisition of the estate etc. inserted by the first Constitutional Amendment Act 1951. Exemption of the fundamental rights. Four categories of the laws can't be challenged in the court of law and on the grounds of they have against the Article 50, 14 and Article 19, and the acquisition of the estate Jagirs Inam Mufassil, the taking over the management of the properties by the estate, amalgamation of the cooperation, modification of the rights director of the scholars and the cooperation, modification of the marginal leagues, the estate law may minimal for the judicial review. if the if the law has been reserved for the asset of the president and be received by the state by the president. Article 31, a right to the property and the individual cultivators below the certain ceilings of fundamental rights. Adequate compensation needs for the given to the such activities. If adequate compensation not given in the individual cultivators can be the approach to be the Supreme Court. Article 32, the right to property, two category of which the right to the property is still fundamental rights. Minority fundamental institution. Article 30, the individual cultivators having individual cultivators having land below the certain ceiling limit etc. 31, a estate the bound by the pay the adequate compensation to the both categories it feared the land and acquired. Article 31b, Article 31b, validation of the certain act regulation and the inserted by the first Constitutional Amendment Act 1951, inserted by ninth schedule and in the Indian Constitution. If the law is regulation replaced the ninth schedule, there can't be the challenge in the court of the law. In ground of the violation of the fundamental rights immunities of the individual. Article 31b of the border, and then the Article 31, Article 31 over the only five categories and two fundamental rights, 14 and the 19, and the Article 31b covered the broad range of the range of the tropics and all the fundamental rights. Kesavananda Bharti case versus State of Kerala 1973. If the law is against the basic structure of the Constitution, it can't be challenged in the court of the law. The Woman Rao versus Union of India 1980, the Act is ninth schedule will be valid only in the don't go against the basic structure of the Constitution. Higher Coelho versus State of Tamil Nadu 2007, the blanket immunity can be given to the laws by the judicial review if the law is against the basic structure and it can't be the declared by the white. Declared by the white. A judicial review itself a part of the basic structure can't be taken away from using the ninth schedule. Article 13C. Article 13C saving the laws given to effect of the certain directive principle inserted by the 25th Constitutional Amendment Act 1971. Any law passed by the legislature to implement DPSP's Article 39B and Article 39C that can't be the declared void by the go against the Article 14 and 19. It's if the law declared that the implementation Article 39B the Article 39C the act is does not implemented in the principle. If it can't be the challenge in the court of the law declared as the unconstitutional. Kesavananda Bharti versus State of Kerala 1973. Judicial review of the part of the basic structure of the Constitution. 42nd Constitutional Amendment Act 1976 and they explore the scope of the Article 31C. A law is implemented by the DPSP if it against the 14 and 19 they can't be the declared void. The Minerva Mills versus Union of India 1980, the Supreme Court held in the unconstitutional current position and the Article 39B and the Article 39C have the procedure over the Article 14 and 14 19 and any law is implemented by provision of Article 31C if it is the passed by the state legislature needs for the and the presidential assessment become a law and then any immunity from the judicial review. Article sorry right to the constitutional remedies. Article 32. Article 32 remedies for the enforcement of the right to the conferred by the this right the positive fundamental rights available to the citizen and the foreign not absolute reasonable restriction allowed the enforcement mechanism for the fundamental rights. The right to the get fundamental rights to protect the fundamental rights itself. Dr. Ambedkar, the Article 32 most important article of the Indian Constitution, the article without which the constitution will be nullity. Heart and soul of the Indian Constitution. Article 32 part of the basic structure of the Constitution. In the case of the violation of any fundamental rights, a person can be approach the Supreme Court directly without the approaching the lower court and the High Court and the Supreme Court. And the Supreme Court issue the writs and order for the enforcement of the fundamental rights, habeas corpus, quo warranto, and mandamus necessary, and the prohibition. The parliament power to give the authority to issue all the any of the rest other courts to their the violation of the fundamental right within their the local jurisdiction the without impeaching the power of the Supreme Court and issue writs. Article 32 part of the basic structure of the Constitution should not be suspended only where the suspended Article 32 through the supervision of given to the Constitution. Article 359 of the Indian Constitution. President can the suspend the right to the move the Supreme Court during the national emergency. Enforcement of the fundamental rights. That its judicial jurisdiction under the Article 30 original jurisdiction of the Supreme Court can be directly approached to the Supreme Court in the case of the violation of the fundamental rights without approaching the lower court. The writs jurisdiction not exclusive jurisdiction of the Supreme Court. The High Court with the jurisdiction Article 33226 aggrieved the person can be moved the higher court and the other Supreme Court. Article 32 only to the safeguard of the fundamental rights. Other constitutional and legal rights can't be the protected through the Article 32. The ruling of the Supreme Court fundamental rights of the person to move the Supreme Court in the case of violation of the fundamental rights. If the fundamental rights is violated, any high court can be helped to protect the inferred right. The person should be the first to go to the rights high court, and the concept of the rights and the jurisdiction borrowed from the UK. The Supreme Court or High Court. The Supreme Court issue the writs only for the violation of the fundamental rights. Supreme Court writs jurisdiction the narrower, and Supreme Court can issue the writs throughout the Treaty of India. Supreme Court in the case of the violation of the fundamental rights, Supreme Court can't be refused the uh, entertain the petition. Article 32 is the fundamental rights. High Court. High Court can issue the writs from the violation of the fundamental legal and the constitutional right. And the writs jurisdiction is the broader. High Court can issue the writs only for within the respective state and jurisdiction. High Court can issue the outsider their jurisdiction only in the case of the action of within their jurisdiction. Article 226 is not a fundamental right. The High Court, the discretionary power under the Article 226, can refuse the intent of the petition. The Supreme Court, issuing the writs under the Article 32, just one of the power, and the order and the direction to the authority can be issued, enforce the fundamental right. The res judicata, reasonable restriction over the 32. If the question has been the decided once, it can't be the taken up against the Supreme Court, giving the finality to the judgment of the court. The habeas corpus, meaning to the meaning to the produced body, ensure the liability to the individual issued by the state and individual person. If a person is detained, if they detain is illegal, the person will be the released, not in the issue of the certain case when the detention throughout the order of the court. If the detention is the lawful, in the case the contempt of the court or the legislature, detention is the beyond the jurisdiction of the court. Mandamus क्या है? Meaning the we command, asking the designated official to the perform duties. The issue when the applicant has been the right to the performs the duty by the official can be issued only for the government official, public official, and who refuse to perform their duty can be issued the public body, public cooperation in and the inferior court, tribunals, and government can be issued the government or the official not be offense of the law. It's against the fundamental rights. The body against the whom to read writs mandamus is issue is bounded by the perform the duty. The Supreme Court can issue the mandamus in the case of violation of the fundamental right. If the High Court can issue the mandamus in the case of violation of fundamental rights, legal constitutional rights. The mandamus issued against the government if they direct the government to the perform the duty or its implement a law. But not make a law the separation of the power. And the writs of the mandamus can't be issued to the private individual, can't be issued where the can't be to issue a instruction don't process or process statutory force, can't be issued when they are the duty and discretionary in nature, can't be issued in the enforce or the contract, can't be issued against the president of India or governor of the state, can't be issued against the Chief Justice of the High Court, can't be issued against the MP, MPS Speaker, Chairman. Writs of the prohibition, meaning to the forbid. issue by the higher court to the lower court or a tribunal can be issued only for the judicial quasi-judicial authority to not hear a matter. If the goes beyond the jurisdiction of the lower court, mandamus issued to the lower court to the take action. Prohibition issued to the lower court to stop taking action can't be issued against legislature or executive private individuals. Any offer not having the judicial power. Prohibition to keep their lower courts within their jurisdiction. The accessories issued by the higher court to lower court or the tribunal. The cause of the order to pass by the lower court grounds of the issue the accessory access to the jurisdiction. The lack of the jurisdiction circumstances can be lead to the lack of the jurisdiction. Court in the part of the properly constituted subject to the matter is beyond the jurisdiction of the court. Jurisdiction decided based on the wrong facts. A decision given to the matter within their jurisdiction, but a wrong decision given to the error of law. Accessories can be issued. Similarities with prohibition and accessories. The both issue against the judicial and quasi-judicial bodies. Both the issue can be where the lower courts and the against the jurisdiction. Both them the issue and the protect the natural justice. Differences between and the prohibition and the accessory issue a different stage of the case. The prohibition at the beginning of the middle of the case before the delivery of the verdict. The accessory after the delivery of the verdict. The accessory is the not available against the legislature, executive, private individual, and co-aranto, meaning by the what the authority the issued by the court of the person to be the know what the authority to be holding the public office to prevent illegal occupation for the public office can be issued only in the case of the public office are permanent nature created by the constitution or a law and there is a violation of the constitution or any such appointment can be issued against the ministers against the private individuals in the office of the held in the pleasure of the another person. Any public minded the person can be approached to the court issue the co warranto whether the right to have been the violated not. Article 32A. The constitutional validity for a state law not considered by the proceedings under the Article 32 added by the 42nd Constitutional Amendment Act 1976 repealed by the 43rd Constitutional Amendment Act 1977. Article 33. Article 33 power of Parliament modify the right to confirm the Part 3 of the application of the force. Parliament has power to restrict the abroad the fundamental rights available to the only by the laws passed by the simple majority. Members of the armed forces, member of the force are charged within the maintains the public order and policy and parliamentary force. Person to the employ the intelligence people employed the and the telecommunication within the above force. The purpose, proper discharge of the duties maintains the discipline, exclusive power of the parliament to modify the fundamental rights and a state legislature have this such power. Any law is passed under the Article 33 not a subject to the judicial review for the abrogation of the fundamental rights. Example, Army Act 1950, Navy Act 1950. The Air Force Act 1950, Police Force Restriction against Act 1966. Members of the armed forces include not just soldiers or other employees, carpenter, plumber, barbers, etc. Using the powers under the Article 33, the Parliament can exclude court martial law or its jurisdiction of the Supreme Court or High Courts. Article 34. Article 34 restriction on the right formed by the Part 4 while the martial law in the force. The term of the martial law not defined in the Constitution. The concept borrowed from the UK, the broad meaning the civil maintaining the more functional military running and that deny the any administration used by the during the state and war of armed rebellion restriction on the imposed on the citizen to restore the law order, the giving the extraordinary power to military such the more than moral times. The article 34, the parliament has power to the pass a law to protect the government and the military offense and the liabilities for the action uptaken during the martial law. Immunities can be extended both the people action government and the servant as well. Any such laws passed under the Article 34 can't be challenged in the court of the law on the grounds of the violation of the fundamental rights. Any law passed by the parliament under Article 34 violated the punishment given to the person during the martial law, any property seized during the martial law writs habeas corpus by issue. The martial law fundamental rights may be the suspended. Have martial law suspended ordinary laws in the court. Martial law restore the background or the breakdown the law of the law and the order. Martial law not defined. National emergency impact the fundamental rights, impact the center state relation. National emergency does not suspend the ordinary law and court. National emergency imposed the third grounds war, external aggression, armed rebellion, detailed the emergency provision in the constitution. Article 35. Article 35 legislation to give effect of the provision for this act, the power to make law for implement certain public fundamental rights. The only parliament, the state legislature don't have this power to ensure the uniformity in their the implementation matters exclusively for the parliament residence condition for the public job. Article 16 giving the writs jurisdiction of the local court. Article 32 modify the rights for the force. Article 33 the provision for relating to the martial law. Article 34 the evolution of the untouchability and Article 17 evolution of the forced labor bearer act. Article 33 the parliament can make a law to the above matters, even though they are the deeds in the state list 7th schedule. Above the law matter before the commencement of the constitution shall be continued to be in force unless the modified or repealed by the parliament. Criticism of the fundamental exclusive and number of the reasonable restriction and the explanation making them the complex. Fundamental rights are the mostly political in nature. Social and economic rights missing the important words not defined. Minorities, public order, martial law, other authorities and presiding over the law and not permanent can be the amended by the parliament. Suspension during emergency, expansion remedies, expensive remedies, justice in the costly not everywhere on the afford it. Arbitrary power of the state in the matter of the preventive detention. No democracy in the cooperative the preventive detention in the constitution. A constituent philosopher make there the imputation of the difficulties right to the outside part 3. The certain right given to the outside part 3 of the Indian Constitution, known as the constitutional right, they are not fundamental rights. Article 265 no tax shall be levied except the by the authority of the law. Article 300 a right to the property. Article rights outside part 3. Article 301 trade commerce and the intercourse throughout the treaty of India shall be free. Article 326 election of the Lok Sabha and state legislative assembly shall be on the basis of the adult suffrage. In the case of violation of these rights can't be go the Supreme Court or under the Article 32 can't be go Article 226 High Court. आपका फंडामेंटल राइट्स हुआ ख़त्म. थैंक यू.